New at 6, a southern Maine man cancels a check and he ends up in small claims court. He's only sued there by a business he has never heard of.
The I-Team discovered the law isn't on his side. Tonight, we're sharing his warning for other consumers and breaking down what it means for Mainers who rely on checks.
I wrote him a check for gas.
Len Sherwood says he was just trying to help out a neighbor when he gave the man a check for $150.
Because he needed a job, a paving job down in Virginia, and he was going to drive down there.
Days later, he says the check hadn't cleared, so he went to his bank, paid a fee, and asked for a stop payment.
What made you cancel the check?
It wasn't cashed. You know, a few days went by and it wasn't cashed. So okay, so maybe he frauded me out of my own pocket.
2 months later, this letter came in the mail from a local business called Republicash, stating it had cashed that check, and as a result, Sherwood owed them the $150 plus a $35 return fee.
Okay, so it must be a scam.
Turns out it's no laughing matter. Sherwood is now being sued in small claims court for more than $400 with added fees.
And I'm like, you got to be kidding me.
Republicash General Manager Scott Provencher says the company is entitled to that money.
We have no idea what took place between the payor and the payee. We're just the ones stuck with the cash out the door.
You're kind of the middleman in all this.
Yeah, that's the holder in due course. It's the law.
The holder in due course doctrine is part of a huge set of commercial laws known as the Uniform Commercial Code, which was adopted by the state of Maine. UMaine Law School professor Andrew Kaufman is an expert.
Everybody to whom the check is transferred is called a holder.
As long as a check is endorsed and transferred in good faith for value, and there's nothing to suggest it's been forged, altered, or is overdue, then you become a holder in due course. It means that check holds its value, and except in very unusual circumstances, you should be able to enforce the check against the person who wrote it, even if there's a stop payment.
You should be able to treat the check as the functional equivalent of cash.
Republicash claims that was the case when it cashed the check from Sherwood's neighbor. Provencher says they have no way of knowing a check has been canceled.
The only way to know is when after we cash it, it goes to the clearinghouse and comes back to us 3, 5, maybe 7 days later with a check copy marked stop payment or refer to maker.
While a bank would just take that money back out of a person's account, businesses like Republicash don't have any collateral.
Consumers need to understand that, checks were made to be written, and if it happened to be cashed, it could come back to haunt you.
He says this happens most commonly in disputes between homeowners and contractors. One example is this case out of Cape Elizabeth. According to court documents, an elderly woman stopped payment on a $1,200 check after her daughter said she was vulnerable and taken advantage of. But since the contractor had already cashed the check, the court ruled in favor of Republicash and ordered the woman to pay. The judge wrote her only remedy would be to pursue a civil claim against the contractor.
The law is really very clear that a stop payment order in and of itself doesn't shield the maker of the check from liability on the check.
Can you understand how a consumer would be caught off guard?
Oh, people don't understand how this works, okay?
Sherwood is learning it all for the first time and warning other consumers so it doesn't cost them too.
I'm just waiting for my day, stand before the judge, and I'm sure, like everybody else, I'm going to have to pay.
Well, generally speaking, Kaufman says you should treat checks as cash. Once you hand it over, you are committing to the payment. The other advice is to pay by credit card whenever possible. That gives you the chance to dispute a charge.